why don't we kick it off? Sure, some people come a little bit late. I usually am to these types of things, but we will start. So first of all, thank you to everyone who's come along and joined this. It's definitely an interesting topic, and I believe everyone that has a key part or manages a business should be having a close look at this information and seeing what they could do to improve the understanding in their organisation and potentially put some protections in place. So this is the second in the series on the privacy law changes that we've done, and we may do another one, but at this stage this is the only one we have planned. Yeah, so I'm joined by, so my name's Colin Daly, for those that have not seen one of our previous webinars before, and I'm the General Manager of the IT team, and I'm joined today by Graham Crombie. Graham, do you want to do a wee intro?
Hi, thanks, Colin. I'm Graham Crombie. I'm a partner in the corporate team at Lane Neave, specialised in technology matters, including privacy and data protection, procurement, and IP issues related to technology. I help startups, SMEs, large corporates, and technology providers with their corporate commercial needs. I've been fortunate enough to work on some of the country's largest technology projects, including what was now many years ago, when Telecom, as it was then, outsourced all its IT function to EBS. Anyway, that's enough about me. Hand back to you, Colin.
Thanks, Graham. What I'd like to say is we're going to have some chance for questions at the end, but please raise them during the session. I might either interrupt Graham if it's interesting enough, or we'll wait and go through some questions. So fire them out during the session, or any comments if you want to debate or add your 2 cents on any of the information we're putting up, then feel free to as well. And we're going to have a couple of polls throughout, so appreciate participation in those. We don't keep the data on what your poll entries are, so we also will be recording this. Yeah, there's a chance that any questions that you put up, no one will know who the attendees are on the recording course, but there's a chance that some of the questions you put up may be on the recording. So firstly, I'm going to kick it off with poll number 1, which is about your familiarity with the new privacy laws. Hopefully that has popped up for all the attendees. So this is just, these polls just allow us to get a bit of an idea of who's in the room and the level of knowledge, and it kind of sometimes allows us to cater some of our information and the amount of detail we go into on the fly. Give another sort of 30 seconds, let it go to 1 minute. All right, we might just finish up there. Someone has ticked this isn't my first privacy law webinar, so that person can probably school us on some things perhaps. But yeah, there's a very good mix. There's quite a few people, the majority of people have read a little bit, but keen to learn more, which is great. And it is understandable. Some people have not heard of this. So hopefully we can be beneficial to all of you, even that person that's attended one before. Hopefully not our one. Okay, right, now poll number 2. Just one more, which is just to try and understand your organizational privacy posture or priority. As best you are aware, you may not be the decision maker on privacy, but you may understand it and understand your position and influence. And it's important to be honest, with this data. Sometimes we look at it and go, that's what we should be, but it's not necessarily what we are. Interesting. Still changing, right? I'll end poll. Oh, more. All right. So obviously, it's quite clear that for the results that the client customer personal data security is our greatest concern, which does fit with this webinar. Now, what we'll talk a little bit later is, I guess, the changing focuses that we've seen in the technology space for security. But it is understandable, depending on the data that you have, that you're more concerned about data loss and productivity impact. This does help us, though, so thank you very much for chucking your details into those polls. We do have another poll a little bit later on, but we will come back to that. So we shall start. So before we kick in, the attendees for this webinar, there's a bit of a mix. Some are our customers, some are people that will not have heard of the IT team. So just a little bit about us. So whilst I'm the general manager and one of the founders, we were formed in 2011, and Office 365, or Microsoft 365 as it's now referred to, has been a big part of our organisation since its inception. And when Office 365 came out and when the IT team was formed is around about the same time, coincidentally. What we do basically, though, is we do managed services or IT support. That's the core of what we do. And as part of that, like most IT companies or managed service providers, we do everything. Basically, if it plugs in, we support it. Great.
Thanks, Colin. So a little bit about Lane Neave. We trace our history back a bit over 150 years now. Established in Christchurch, now with offices also in Auckland, Wellington and Queenstown, so we're a national firm. We're also a full service law firm, so we cover all the key areas that you need legal advice on, such as corporate, commercial property, employment, dispute resolution. We have a number of specialist expertise, which I've already talked about. And largely, it's our job to provide relevant and practical advice, making complex legal problems simple.
Brilliant. All right, so just a little bit about what we're going to cover today. So we're going to talk about the timeframes for this legislation or law change, which is still the same as it was a month ago, which is good. Then we're going to talk about key changes to the information privacy principles, and then some of the examples of what are notifiable privacy breaches, including some examples that Graham's going to take you through. Then quickly, we're going to touch on the powers of the Privacy Commissioner, the office, not necessarily just the person, and some of the new fines and penalties that organisations such as yourself could be out for. Then I'm going to jump in and talk a little bit about some of the protection options that you could consider, and that's going to include the priorities, which is kind of refers to the second poll that we did. We're going to talk about something called the security scale, and I guess look at how Microsoft 365 does fit into this. Now, most of the people attending this webinar, but not all, and we'll have a poll on that, will be using Microsoft 365, and it does have a lot of tools to help you protect you. So we will be talking a bit about that. Then we'll quickly go into what you need to do and some recommendations for you going forward, and then we'll have a session for questions. Right, Graham.
Oh, thanks, Colin. So in terms of timeframes, the Privacy Act 2020 has had a long period. The Law Commission first talked about it about a decade ago. We got a bill introduced finally in March 2018, and then it has taken a bit over 2 years to work its way through Parliament, finally approved through Parliament at the end of June this year, and it comes into force on the 1st of December. It's going to modernise the existing privacy laws under the Privacy Act 1993. Most of it stays the same, but there are some new things, and this is what we are largely going to touch on in this presentation. Moving on, one of the cornerstones of the Privacy Act is the information privacy principles, and I thought it would be useful to just briefly touch on these to remind people what it all relates to. So, in working out what Privacy Act 2020 applies to, you need to look at two things. who does it apply to, and what does it apply to? So to apply to an agency, and that's pretty much anyone. So an individual, someone from the public sector, someone from the private sector, and even overseas persons. What it applies to is this concept of personal information. Now that's information about an identifiable individual. An individual is a natural person, someone who is alive. The key part of the definition is really the two words between information and individual, about and identifiable. So there needs to be some sort of link between that information and the individual. And the information can be anything from a name to an IP address. But without the link between the two, it's not personal information. So for instance, the information 5'1" is pretty much meaningless. But if I was to say that I am 5'1", I'm actually a bit taller than that, but for the purposes of this example, that would then create personal information. What it doesn't cover as a result is corporate data. So anything that's about the organisation itself or about things. So with that background, let's have a look at what some of the changes are. So our first set of changes are in the core privacy principles themselves. Under the current legislation, there are 12 privacy principles. Under Privacy Act 2020, there will be 13 privacy principles, the existing 12 plus a new one. 5 of the existing principles have been updated, largely minor changes. I'll quickly run through those changes. Principle 1, which relates to the ability to collect information in the first place, is tweaked so that collecting identifying information is restricted. So if you haven't got a lawful purpose for collecting the identifying information of someone, then you should not collect that information. Principle 2 relates to who you collect the information from. And the key there is to collect it from the individual concerned. There are some exceptions, and one of the new exceptions added is around serious threat to life or health. Now this just aligns with some of the other principles that also have that exception. Principle number 4 is about the manner in which you collect information. And this is probably one of the key changes here. What's been added is a requirement to take more care and consider more carefully where you collect information from children and young persons. So do you really need to collect from them, and are you really collecting it in an appropriate manner for children and young persons? Moving on to Principle 8, that requires the accuracy of information to be checked before you use it. The change under Privacy Act 2020 is to require accuracy to also be something checked before the information is disclosed as well as used. In practical terms, that's unlikely to make much difference because most disclosure also requires a use. Principle 12 I'll get to shortly, that's the new one. Principle 13 is the old Principle 12, dealing with the use of unique identifiers, so the customer number you allocate to someone. This has a tweak that largely accords with pretty common practice these days, a requirement to minimize the risk of misuse of that unique identifier. So if it's printed on a receipt, for instance, truncate the details so that it's not all, so the credit card detail, for instance, isn't entirely shown. The key action here is just to review your privacy practices and policies and update them where necessary to make sure that these slight changes are incorporated within your privacy practices and policies. And these could be both your internal documents that set out the basis on which you're going to handle personal information and the external facing documents you have. So the privacy policy on your website and the privacy statements you have on forms that collect information. Moving on to principle number 12 then. This one relates to disclosing personal information outside of New Zealand. Now this is triggered if you disclose it to a party outside New Zealand who is going to use the information for their own purpose. If you're disclosing it to them as your service provider and they're just going to process it on your behalf, for instance, you're storing it in Microsoft Azure, then this principle doesn't apply. You have to fall back on principle number 5, which is the requirement to have reasonable security in place. And that's what Conan will certainly be talking about later on.
Could you give an example, Graham, of the giving disclosure to a company outside New Zealand that's not a service provider, like a real world example?
So one situation where this can happen is just some of the marketing providers that organizations use. So for instance, Mailchimp, under its privacy policy, it uses the information provided to it for its legitimate purposes of managing its own business and improving its services. But that means it is using that information for its own purpose. So that is going to trigger the new IPP12. It means that you can only disclose the information to those third parties. And I guess the most likely scenario here is where you have in some sort of relationship with another party that involves you passing that information on for them to do something with it for their own purposes. What you have to do under IPP12 is either have the individual authorize the disclosure, or if not, be satisfied that the party outside New Zealand is subject to appropriate privacy legislation. And there are a number of options for that. They could be subject to Privacy Act 2020 because whilst they're overseas, they also do business in New Zealand themselves. They could be subject to laws that provide comparable safeguards. For instance, if they're a company in the EU, they'll be subject to the EU's GDPR, which in our view would provide comparable safeguards to Privacy Act 2020. Thirdly, they could be part of a prescribed binding scheme. That's something to be seen in due course and will require regulations. There aren't any at this stage. Fourthly, they could be subject to the privacy laws of a prescribed country. We don't have that as yet. That will also be set by regulation. The key aspect there will be that the government will have done the exercise in that second bullet point to work out if the legislation provides comparable safeguards. So you don't have to work it out yourself. You just go, are they on the list? And lastly, if none of the other options work, you can put in place a data protection agreement with that other party to ensure that they comply with relevant aspects of Privacy Act 2020, so that by contract they provide those safeguards. The key thing here is to just check your contracts with third parties and update them where necessary to make sure that if there is a disclosure to a company outside New Zealand, it's fitting with this privacy principle. That's enough on the privacy principles. If we move on to one of the key changes under Privacy Act 2020 is the introduction of a notifiable privacy breach regime. So what I'm going to do is I'm going to quickly run through the regime and then a couple of examples. The first part of the regime is to assess whether there's a notifiable breach. And there's two parts to that. Firstly, is there a breach of privacy? And this is defined as things like unauthorized access or accidental disclosure of information. So any access or disclosure of personal information that was unauthorized will be captured. It also captures an inability to access your information. So if you suffer the CryptoLocker virus, for instance, and all your files are locked up, that can also constitute a breach of privacy. However, it doesn't necessarily mean it's notifiable. There must also be a serious harm element. So the breach has to either cause or be likely to cause serious harm. Now that's not defined in the legislation, but the legislation does give us a number of factors that need to be considered in working out whether or not there is serious harm. And these are things like who it was that got the information, the nature of the information itself and how sensitive it was, what you did to reduce the harm following the privacy breach, the type of harm that could be caused, and also whether the information was subject to some sort of security protections, i.e. was it encrypted. Things like a threat to physical safety or credit card fraud are going to be obvious examples of serious harm. There are a few exceptions to having to notify. These are largely tied to where notifying the individual would cause them undue harm. So it would prejudice their health by notifying them. There's also a defence if you reasonably believed you didn't have to notify. If you do have to notify, you have to notify the affected individual and also the Privacy Commissioner. And you need to do it as soon as practicable once you become aware of the breach. As soon as reasonably practicable once you become aware of the breach. There is a right to delay that notification. That's in the situation where there's a risk to the security of the organisation by making the notification. Say a hole in your security has been discovered, and that's what's led to the breach. If you notify people and tell them about this hole to the security before you've done something about it, then you could have greater privacy breaches occur. So you can delay it till you address the issue. What you have to notify is set out in the legislation, but it's pretty much what happened and what you're doing about it. One key thing to remember is that breaches by the service provider are the responsibility of the party collecting the information. So party collecting the information is the one that has to make the notification. The key action here is to just have an assessment process in place now. So think about what your data holdings are, what sort of harm could result if there was a breach, what types of breach could happen, and work through the first step so that you know in advance what the issue might be and whether you'd have to notify or not, rather than having to work it out on the fly. So if we look at a couple of examples, first of all, we've got Paul, who's been asked by Kate, his organisation, to send in payroll information. He types up his email, attaches the file, puts Kate in the two-line, auto-complete completes the email address, and he sends it off. And he then realises that autocomplete brought up a different Kate, not the one in his company, but at a different company. Quickly contacts Kate. She deletes the file and confirms it hasn't been accessed or copied. Good news is Paul regards Kate as reliable and trustworthy, and there's a contractual relationship between the two companies. So if we look at these facts against the regime, first question, is there a privacy breach? Clearly there is. There's been unauthorised disclosure of information, gone to the wrong person. Second question is whether or not there's serious harm. Now, in this case, our view is no. Kate is reliable and trustworthy. She's deleted the file, and we'd want to make sure she had deleted it from her inbox and her trash, and it hasn't gone into backups, and it hasn't been forwarded to anyone, hasn't been otherwise copied or printed out. And there's an ongoing relationship between the parties of a contractual nature. So if we look at some of those factors, the action that was taken and the individual to whom it went to are the key factors here to say, look, there's not serious harm. There would still be some actions that the company would want to take. You'd want to do a bit of training and certainly reminders on the care you need to take in using autocomplete in your emails. Our second scenario, so this relates to an online retailer. Oh, next slide, Colin. Thank you. So we've got aptly named retailer eStore, who's engaged an email marketing platform provider to communicate with its customers. Chris at the eMarketer discovers that eStore's mailing list has been downloaded by an external party. It's got quite a lot of personal information in it. And it turns out that Peter had received an email with a link in it that turned out to be malicious software that was downloaded to his computer. And it enabled Peter's logon details to be collected and then used by that party to get in and get the mailing list. But worse still, some of eStore's customers are getting emails pretending to be from it and asking for credit card details. So if we go through our analysis again, is there a breach? There is clearly a privacy breach. There's been unauthorized access to information here. Is there serious harm? In this case, our view is yes, there is. You've got an unknown party that's got hold of the information. They're already using it to conduct further phishing emails to obtain financial information. The information could be used for identity theft. And there's a real chance that some of these customers are going to fall for the email and provide credit card details and suffer financial harm, not to mention the stress from this hack. So what would eStore need to do? It needs to notify the affected customers, and it needs to notify the Privacy Commissioner. It needs to tell them essentially what's happened and what they're doing about it. What they are doing about it would include things like resetting Peter's login credentials and hopefully investigating the likes of two-factor, multi-factor authentication to make such an attack much harder in the future. And Colin will get onto some of these security things in due course. They should also advise customers what action the customer should take. So for instance, be on the lookout for these emails, delete them, provide a message that eStore would never ask for credit card details via an email, and also advise customers, if they happen to have provided their details, to contact their bank immediately. That's pretty much that for the examples. If we briefly look at some of the other key changes, the most significant is around the Privacy Commissioner's new powers. And one of these is the ability for the Privacy Commissioner to issue a compliance notice. So this is where the Privacy Commissioner thinks your privacy practices aren't up to scratch. So they'll consult with you and hopefully bring you along to the point that they're satisfied. And you have an ability to work with them to get to that point. However, if they don't think you're engaging with them or you're not really doing what they ask, they have the ability to actually issue a compliance notice, and that will set out steps that the organisation must take and a time frame within which those steps have to be taken. It will be mandatory to comply with that notice. The notice can be enforced in the Human Rights Review Tribunal, which is where privacy matters go. It can be appealed if the organisation disagrees. And in addition, the Privacy Commissioner will have the discretion to publish the names of any organisation that he has issued a compliance notice to. So this fits with the Privacy Commissioner's name and shame policy to try and help improve privacy practices amongst organisations in New Zealand. Other powers, there will be an ability for the Privacy Commissioner to direct an agency to provide access to an individual requesting their personal information. That also will be mandatory and enforceable, unlike the current situation where it's just a recommendation. There will be some more tools for investigation, essentially allowing the Privacy Commissioner to shorten timeframes so that agencies can't draw out an investigation, and that will bring it to conclusion much quicker. There's also the ability for the Privacy Commissioner to take whatever other action it considers appropriate if a complaint isn't resolved to the party's satisfaction. We will have to wait and see from the Privacy Commissioner's guidelines as to what things that might actually enable him to do. And lastly, there's the ability to share information with overseas agencies. So this is where there's a global breach and a New Zealand agency and another agency are investigating. The Privacy Commissioner can share with his counterpart overseas to help their investigation and obtain information from them to help his investigation. The key thing here is to just check that your privacy practices and policies are compliant so that you reduce the risk of being on the receiving the end of a compliance notice. Next slide. There are a few new offences that have been introduced into Privacy Act 2020. From an agency perspective, the two key ones are failing to notify a breach to the Privacy Commissioner and failing to comply with a compliance notice. In both those cases, if the agency is prosecuted, they can be fined up to $10,000. This is well less than the fines in other countries, particularly Europe, but there is a fine nonetheless. I think that brings us to your part, Connor. Talk about the security side.
Thank you very much, Graham. So what we're going to do is just talk a little bit about what you could do and may consider from a security point of view. Before we kick that off, I'll chuck a poll up, which is poll number 3. So as I mentioned earlier, this isn't about Microsoft 365, but because that is where a lot of people's data is, increasingly so. And it's a lot of where the protection measures can come in. We're just going to ask a couple of questions around Office 365, Microsoft or Office 365. So hopefully a poll launches now. Great, there's a few in there. Oh, still coming in. Not too many people are asleep, it seems, which is good. All right, I'll end the polling there and share the results. So obviously, the majority of people are using it either somewhat or extensively, which is great. And there's a couple that are not sure. So we've got a bit of both things related to 365 and not related to 365 here, but it's likely going to apply to many people in this session. So continuing on, just setting the scene. So traditionally, the IT team's been involved in security for some time, and you know, if you went back five years, maybe even 3 years, the leaking of customer private data or personal private data was not often the highest priority. This is a bit of an idea about the priorities that we saw. So originally, in the earlier days, organizations having just productivity impact, the ability to, you know, stopping them from working was the greatest concern from a security point of view. So ransomware attack, it wasn't about the loss of data to people that could use it for contacting their customers in a nefarious way. It was more about how long we're going to be unable to use our workstations, and potentially loss of data as a productivity element was always the greatest concern that we people wish to protect themselves against. Secondly, organizations and individuals having a reputational impact. So your company suffers organization suffers a security breach, and people learn about it, and it makes you look bad because you don't seem to be protecting your data or good with your IT. That was always a high priority. As we go further down, business secrets or their finances being leaked out and actually being used, not just the reputational damage of that, was a concern. And then only then would we get to the point, which is the key element we're talking about here, where our customers' personal private data was being leaked out. Furthermore, going further down the chain, you have accidental leaking of sensitive data, and that's from your staff. That was always considered, you know, 5 or 6 years ago, a pretty rare thing, and people didn't usually ask about how to protect against that. And then lastly, intentional extraction of data. So that'd be your staff members, you know, emailing a document to themselves on their Gmail or other versions of leaking of data. So that was always pretty rare. People just thought, well, if they're going to take it, they're going to take it, chuck it on a pen drive, whatever. But this is an idea of where the priorities were, and nowadays with this legislation and other activities, what we're seeing, as you saw in the original poll, is that number 4 is rising further to the top. So just to break down the different classes of protection. So continuity, what we said earlier, people's ability to keep working, people's ability to not lose their data or productivity is an area of security. Secondly, we have the data privacy and security. So, you know, third parties extracting data and how to and trying to prevent that. And then lastly, the traversal exfiltration protection, which is a bit wide, not the best description, but it's effectively preventing unintentional and intentional data leaks from the inside. So what we have here, this is a Microsoft diagram here, and we're not going to read it, but this is how Microsoft and we have used this to effectively look through the different elements of protection that can be in place through the various types of, as you can see here, types of attacks and the phases of an attack. So you kind of have phishing, for example, versus brute force, and there's the start of it versus to the end of it. And there's various technologies at various points along that can protect against that. So this is a document if you wish to find. We could certainly link it up, and it's quite extensive. And we don't have all of these, and we don't recommend all of these. As you can see, there's probably 30 different, you know, settings or technologies you can implement. But we use this and the Microsoft tools to determine how we recommend protections for our customers. So now onto this. This is what we call the IT team security scale. It's not just for customers. Hopefully people in this webinar can get some benefit from it. We've developed it, and it's taken us a fair amount of time to understand the situation and put our recommendation in place. But we've developed it to try and help people to understand the priority of various technologies, give a bit of a self-assessment, or get another page to do an assessment, and determine, I guess, where they want to go. So yeah, what is it? Created by the IT team. It's not just M365, but a lot of it is technology that you would find in Microsoft 365. The purpose is to assess your position. It gives an idea of the minimum and recommending standards with the blue and the green to give you an idea about where you are and where you should be. But critically, it assists with the prioritization. So knowing where you should go. Should you go right to number 10 and implement some of those items on the bottom? Well, we would say that, you know, don't run before you can walk. Start on the things that are going to have a greater impact for less work. And generally what you'd see along that list is the effort required to implement gets higher as you go further along. So just breaking these, I'm going to go through these reasonably quickly. And if you'd like more information, please feel free to seek it. But this is about privacy. And this, what we're talking about here, is just some protections that you could consider. So this is kind of the starting point for the 1 to 4 section. So we would say that most organizations should be at number 1, which isn't great. As we say, you should have a minimum password policy implemented, you should have an antivirus, and you should have your machines patched. If you're getting to number 3, point 3, you would have a domain, or your workstations would authenticate against Azure AD. That's a key thing as a baseline. You might have MFA, which is further down the track, or do phishing campaigns, but if you don't have your machines authenticated against a domain, there's a big security gap there. Secondly, which kind of is in the 2 and 4 level, it's a little bit complicated, web DNS filtering, which is a key tool you could use, or Microsoft ATP. So DNS filtering, we recommend Cisco Umbrella, but there are other tools out there. And Microsoft ATP, Mail Marshal, other mail filtering, Mail Assure, these types of tools are good, or Microsoft ATP is built into Office 365. Continuing on, MFA, we classify this at 5. It is, if I could give a recommendation to the people attending this, MFA for all your staff across multiple services, but critically your Office 365 or Microsoft 365 is going to have the greatest level of impact for the level of effort required to implement, and you should consider it. It's very powerful. If you're one of our customers and you'd like to know if you have it, feel free to reach out. Hopefully it's been discussed, but it is a very powerful tool. And then further down, DMARC for assisting with your domains and your email protection, BitLocker for your workstations, and phishing campaigns for training. Getting into the more complicated phases, so this is around the 7 area, DLP, which is about trying to prevent data from exiting your organization. It is a powerful setting or function that you could use for sensitive documents and sensitive folders in your organization. I'll skim through these ones. Mobile device management for home users or mobile devices in use in your organization, and conditional access can be further layers to protect you and your data. Additional security monitoring, data loss monitoring, and risky signers monitoring are getting quite up there, but we do believe they're very important just to allow you to have a bit more information about what is going on. And then Azure PIM, particularly if you have Azure, is about privileged identity management. So if you would like more information on these, we can provide them. But this is just to give you an idea about priorities. You might look at this and go, oh, we're actually doing pretty good. Or you might look at it and go, I thought we were doing good, but we're actually only at a 3. In which case we'd probably recommend you could make some changes. So for those that are using 365, to get access to a lot of the functions required to implement those settings that are above, well, it's scattered across, but generally above a 5, you do need the Microsoft 365 Business Premium, which has some of those settings. Without that, you can only get halfway through. Now, you might believe you already have this if you have something called Office 365 Business Premium, that is now called Microsoft 365 Business Standard, and it has a lot of the functions, but not all of them. So feel free to ask us if you'd like some advice, but we'd recommend if you're security conscious, you get this license. Just getting the license doesn't necessarily give you the settings. There is a bit of work to implement them. So moving back, what do you need to do, Graham?
So just to quickly run through these, we think there's essentially 4 things that people need to focus on in relation to Privacy Act 2020. First is updating your privacy breach response plan. So this is to add that assessment piece that I was talking about earlier about what are you going to do in terms of the notification requirement if there is a privacy breach. So add that into your response plan. If you haven't got a response plan, then you should create one of those at the same time. Secondly, think about contracts with suppliers and other third parties who you provide personal information to. What's the context you're providing it to them in? Are they just processing it on your behalf, or are they using it for their own purposes? You'd want to know that if they're a processor, they're going to alert you if there's a privacy breach they become aware of, and that they're going to take the appropriate action to deal with that breach, investigate it, and fix it. If they're a party that you are disclosing information to for their own purposes, and outside New Zealand, run through that new principle number 12. Thirdly, look at your processes around collecting, storing, using, and disclosing personal information. Are those processes compliant with Privacy Act 1993? And are they compliant with Privacy Act 2020? So we need to update them for those small tweaks to the IPPs, but also we want to make sure that they haven't got out of whack with what the organisation's actually doing. And we often see in the marketing side of things that the website privacy policy gets out of sync with the practices that the organisation's actually undertaking. Now's the time to get that back in sync so that you reduce the risk that the Privacy Commissioner might think your privacy policies and practices aren't up to scratch and starts the compliance process. And lastly, it's looking at IPP 5. Have you got reasonable security in place to protect the personal information that you are collecting? And of course, all your other corporate data, that from the Privacy Act 2020 perspective, it's only the personal information that is subject to that privacy principle. So that's, think about what are the appropriate security measures to deploy and ensure that they're in common run through a number of those and the different options. And that's pretty much it.
Very good. We had a couple of questions that I've just answered on the, feel free to submit your questions, team, everyone on the call. We had a couple of questions already on getting access to this recording and also getting access to the slides. We will make them available on request, and those people that submitted those will get them to you. The video, we'll get it up in about a week, but yes, we will make those available. Just in the meantime, there was a couple of questions that I thought of. So Graham, does that mean, based on your comment earlier, that technically most businesses, because the IT team uses Mailchimp, technically come 1st of December using Mailchimp will be against the wishes of the privacy laws or the Privacy Commissioner?
Well, hopefully not. The Mailchimp's a large global organisation, yes, based in the States. They have already in place provisions that deal with the handling of information from the European Union, so as to comply with the General Data Protection Regulation there, so GDPR. They will hopefully, prior to 1 December, update their policy to make it clear that, and personally the simplest fix from my perspective is that their data protection agreement terms that apply if you're in the EU, if they just simply extended them to New Zealand data as well, then that would address the issue under IPP 12.
I guess if they're not, it kind of shows what they're doing, and I guess why they have free accounts for their customers, because they're obviously harvesting and using the data, which is a bit cynical. Just furthermore, the comment around using personal data for marketing is really interesting. So technically what that means, my understanding, I've seen a few questions coming in, I will get to you in a moment, guys, is that if you are using, you should only collect data if you have a need for it, right? So that means that if, say, we were getting information for I guess a newsletter, the IT team, or a shop was getting information for their customers, how does it work if you are getting kind of information that is, I guess, about understanding markets? So if we have someone, potential customers, and we wanted to know their gender, age, maybe some history things, working history or personal history, And the idea for us is we're trying to understand our market and who wants our services and who's, trying to get a bit of a survey of the market. How does it work? Because we're not going to use that practically. We're just using it for market understanding.
Yeah, so that's a good question, Colin. And it brings us really to principle number 1, which sets out that you can only collect personal information for a lawful purpose that's connected with a function or activity of the agency collecting, and that the information collected is necessary for that function or activity. So you have to look at what function of the organisation you're tying back the collection to, and that may well be the general marketing of the organisation's products. If so, you then need to think about, well, what does this information tell me that's relevant to that particular function? And it may be that most of the information you talk about does have some relevance, depending on who the customers are that you're trying to target. But it doesn't mean you can just collect information on that basis, because it might be relevant, it might be useful, or it would be nice to know. You do have to come back to what's the purpose that the organisation is collecting the information for, and is the information necessary for that purpose? So do you really need to know the age of the people in order to be able to market appropriately to them? Now, if your products are suitable for people aged between, say, 18 and 24, but they're not suitable for anyone else, then clearly knowing age is important. If your products are suitable for everyone, do you need to know age? And maybe you do, because you've found that people in certain age brackets aren't taking up your products. And so you want to understand why that is, so that you can better market those products.
So it has to be justifiable, though. You'd have to, if you
That's right.
you'd have to be able to justify it to the consumer and possibly someone else. And I guess we should be ready for these type of questions. When people say, "Why are you asking my address?" or "Why are you asking my age?" That's probably going to be something that we could expect.
Yeah, and that does happen a bit, but for the most part, most people just go, "Oh, they've asked for it. Okay, I'll provide it."
Yeah, that's right.
But it is important to make sure you've thought about what you're asking for and why. And particularly with that change to IPP1 to say, you've got to think even more carefully about identifying information.
If you need someone's address, you might not want to take it because it kind of leads closer to how identifiable it is.
Yeah, if you don't need it, don't collect it.
Yep. No, that's good. Just another question from Kendra. What does new legislation mean for powers in other acts to issue information sharing codes?
So that's a good question. So other legislation that deals with personal information will continue to apply. The Privacy Act 2020 is in the same way that Privacy Act 1993 is subject to other laws. Privacy Act 2020 is also subject to other laws. So if there's an obligation or a requirement or an ability to do something under other legislation, that will still be the case, even under Privacy Act 2020. Under the current privacy regime, there are a number of codes of practice. For instance, there's a Health Information Privacy Code, and there's a Credit Reporting Privacy Code. Though all of those codes are being updated for Privacy Act 2020, you can expect them to be much the same as they are at the moment, but they will be modernised for the new Privacy Act 2020 language, and they'll bring in those changes to the 5 IPPs and the new IPP that I talked about. Existing information sharing agreements may need to be updated in light of Privacy Act 2020 as well.
Excellent. All right, well, look, one more question. Just in time, Shane. Shane has asked, can you give some guidance on the personal versus corporation crossover? We deal with small business owners who often have one email for both personal and work. If they are providing this address for business-related activity, would this be considered personal or corporation data? Good question.
It is a good question. And it comes back to what exactly is in the information. And if they provide it in a business context, and it's the hard thing with email addresses is they're all personal information. So even when you're dealing with corporates, the email address and the telephone number of the individual at the organisation is that individual's personal information as well. It's just their work personal information. So Privacy Act applies to that information. If, however, the email address is something like info@laneneave.co.nz, it's not associated with a person, so that's purely corporate information. The fact that an individual uses an email address, and I'm assuming in this case it includes their name, for both personal and business, that email address in both cases is still personal information because there's a link between the individual and the information itself.
So I guess it kind of means if there's a name of a person, then it's likely involved. It's a good question. I was wondering about whether if you had a Mailchimp style leak, if it was business versus personal information, could you sort of split them? But it sounds like as soon as it's related to a person and it's not a generic address, it kind of falls under this. Great. All right. Thank you very much, everyone. We will finish up. Questions, if you have any further questions, feel free to put them in the chat or send them through to either of us. There's webinars at the IT team, or send them direct to Graham on the email address that I've shown on screen at the moment, or myself for any of the more technical related questions. There should be a survey going up as you depart. Please fill this out. This helps us to get better. It helps us to potentially, and also there could be some cues that you wish us to give more information, perform future webinars of note, and also there might be some you might wish us to engage you, but only if you tick those boxes or select that information. So yeah, from myself, thank you for attending. We will have future webinars that we'd love you to attend, and feel free to sign up to our newsletter. And yeah, for Graham, I'll let you say your farewells.
Thank you everyone for attending, and hope you found that useful. For more information, there are a number of articles on the Lane Neave website relating to Privacy Act 2020. Feel free to have a look at those articles. If you have trouble finding them, just email me and I can shoot you the links.
Great. Excellent. I did have a few people contact asking for the slides. If you didn't ask, but you would like either the slides or recording, please send a message through to webinar@theittteam.co.nz. Thank you very much, everyone, and you have a great day.